Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll look at a very insightful argument presented in a case before the High Court of Australia, and that case is called Crittenden and Anderson from 1950. This unreported case, decided by Justice Fullagar of the High Court, brings together two things that we have already seen in this channel. First, it refers to the dual citizenship rule in section 44(1) of the Commonwealth Constitution. And second, it relates to section 116, religious freedom in Australia. I find this case quite interesting, to be honest, and despite it being an unreported case by the High Court, decided by one justice only, Justice Fullagar, I still think it's a nice argument and worth to do at least one video about it. So why not just make this short video about it? But of course, if you are keen to know more about more famous cases, some of the biggest cases decided by the High Court of Australia so far, you know what to do. You have to subscribe to our channel, and you can also click the top right corner and check out the playlist that we have on constitutional cases. Well, but here's what happened in this particular case. The High Court of Australia received a petition as a court of disputed returns, according to the Commonwealth Electoral Act, asking it to assess the qualification of a candidate elected in the elections of 1949 for the House of Representatives. The candidate was elected for the electoral division of Kingford Smith in New South Wales. His name was Gordon Anderson. And Mr. Crittenden, the defeated candidate for that same seat, was the one petitioning the High Court asking about the qualifications of Mr. Anderson. The petition basically argued one thing: that Mr. Anderson could not have been chosen for the seat in the House of Representatives because he owed allegiance to a foreign power. That means that he was in breach of section 44(1) of the Commonwealth Constitution. Now the thing is, what was the power to which Mr. Anderson owed allegiance? The answer? The Vatican. The argument was that since Mr. Anderson, at the time of nomination, was a member of the Roman Catholic Church, then that meant that he owed allegiance to a foreign power, the Papal State. That's right, because he was a Roman Catholic, the argument was that he owed allegiance to a foreign power, the Vatican, and to another representative, the Pope. And, as was argued, there was a breach of section 44(1) of the Constitution. Ultimately, as Justice Fullagar said, what the petitioner was saying was that every member of that church is the subject of a foreign power, and for that reason incapable of becoming or being a member of Parliament of either House of Parliament of the Commonwealth. Justice Fullagar gave an answer to that argument, but he said that a full answer to the argument would necessarily go over the history of Italy, the history of the Papal States. And all of that was ultimately irrelevant to the question, the constitutional question about section 44(1) and the election for the seat of Kingford Smith. So the argument was therefore too general to be upheld. The premise could not be sustained as a matter of law, because of a very specific history between church and state in Italy. It is true the Roman Catholics too have this relationship of their religion with a particular territory. That's true, but Justice Fullagar said that one could not be prevented from sitting as a parliamentarian just because they were Catholic. And that leads to the second dimension of the decision, because it is not only about section 44(1) of the Constitution. We have to consider the implications to section 116. For Justice Fullagar, section 116 provides a better answer to the argument than section 44(1) does. Section 116 prohibits any religious tests being required as a qualification for holding any office under the Commonwealth. So then to say that a Catholic could not be sitting at a federal parliament because that would be a breach of section 44(1) would amount to say that no Catholic, because of their religion, could participate in the Commonwealth Parliament. Just because of the religion of that person would ultimately be prevented from holding an office under the Commonwealth. And Section 116 expressly holds that no one will be forbidden from sitting as a parliamentarian or holding any office under the Commonwealth because of his or her religion. So, as Justice Fullagar stated, effect could not be given to the petitioner's contention without the imposition of a religious test. The case was therefore dismissed and Mr. Crittenden was demanded to pay Mr. Henderson's costs. I hope you enjoyed this video and I hope to see you again soon. Until then, ciao.